Good afternoon. Welcome to the new semester. I think it's important that this semester we continue our programs that look at issues concerning race in the law, COVID-19 in the law, and important legal developments. As I said, they'll be on Thursdays this semester, and the first of these looks at the Constitution and lessons learned. There's no doubt that the last few weeks, to say nothing the last 4 years, have been a challenge to our Constitution. What's happened? What can we learn from it? Very fortunate that we have several professors who have agreed to offer their perspectives on this. I'm very grateful to them for taking their time to prepare and be part of this program. As always, I'm going to do the most brief of introductions because it's so important we use the time to hear from them. First, we'll hear from Kathy Abrams, who's the Herma Hill K Distinguished Professor of Law. We'll then hear from John Gould, who's an Assistant Professor of Law. Then from Kristen Holmquist, who's a Professor and the Director of Experiential Education. And then from Asad Rahim, who's an Assistant Professor of Law. And then I'll also speak at the end of the program, each of us focusing on different aspects of the Constitution and the lessons learned. So with that, I'll turn it over to Kathy and then let each of the speakers follow her. We will have time for questions at the end and look forward to them.
Great. Thanks to Dean Chemerinsky for giving us a chance to reflect together on the meaning of what we've been through and where we've arrived. The reactions I'm going to share today stem not so much from my experience of being a con law teacher, although they're surely informed by that, as from my experience of being a citizen. I want to take a critical look at two phrases that have been in frequent use over the past 2 months, and particularly the past 2 weeks. The first is the assertion that the guardrails of American democracy have held. And the second is the suggestion that it is now our job to defend or show fidelity to the Constitution. Well, yes, the guardrails have held in the sense that our democracy has not wholly collapsed. Against all odds, we had a highly functional election with record participation. And even in the face of violence, we had a successful transition of power. But yikes, this was by the skin of our teeth. The constitutionally prescribed checks and balances just barely got us through. And perhaps more importantly, they worked so differently from the way the language of the Constitution or even the logic of the Federalist Papers suggested they might, that sometimes it was hard for me to tell whether it was the result of serendipity or design. I state the obvious when I say that the horizontal separation of powers, federal institutional checks and balances, radically underperformed. Congress certified the election, and the House, after an unprecedented attack on the Capitol, voted to impeach Trump for his explicit provocation. But this is a cause for relief, not celebration. Given the numbers of House members that voted against these two completely obvious moves, it seems clear that loyalty to a political party largely overwhelmed the framers' strategy of connecting the interests of the man, and yes, they were men then, to the constitutional rights of the place. A more unexpected guardrail, at least for me, was the vertical separation of powers, or federalism. This year hasn't been a great advertisement for federalism, as we've watched the state struggle to manage the pandemic without the forceful direction and detailed coordination that the federal government could provide. Yet, in the election and in the challenges in Michigan, Georgia, Pennsylvania, Arizona, I saw something different. When I think about federalism, I often think about the debate between Madison and Jefferson about human nature, the role of politics, what level of government is most effective at bringing out the best we have to offer each other. To me, it's never been an equal contest. The Jeffersonian emphasis on agrarian virtue, small communities, the benefits of face-to-face democracy always seemed to me somewhat mythical and applicable today only to those small New England towns where you can jam everybody together in one large hall. I've always been more of a Madisonian, an advocate of a powerful central government, an extended sphere, comprehending multitudinous variation in geography, experience, identity, interest, someone more willing to trust institutional checks than political virtue. Yet there's been something vaguely Jeffersonian about what transpired during this election. Start with Republican officials and administrators in some of the contested states. There was something about the experience of face-to-face or mask-to-mask democracy, not in its legislative incarnation, but in its hands-on incarnation. Reviewing the rules, supervising the counting of votes, going through the ballots by hand. This experience seemed to bring out a commitment to democracy and to the way it had been accomplished by one's own state that proved to be more durable than the party affiliation that was laying waste to the horizontal separation of powers. I think about officials whose names have become familiar: Brad Raffensperger in Georgia, Aaron Van Langefeld, the 30-year-old in Michigan who bucked some of his party's leaders to certify the state election results. It's possible that these were people of unusual integrity, but they were also people whose face-to-face experience with fellow state and local citizens brought out what in the framers' time we might have called civic virtue, an appreciation of self-governance by democratic means, an affiliation with the good of the state and its people that was stronger than partisan affiliation or than the self-interested desire to win the favor of the most powerful official in the country. But these officials were not the only ones who demonstrated the effects of face-to-face democracy. Perhaps the most moving and important example, in my view, was the Georgia runoffs. We saw the virtue of face-to-face democracy in the work of Stacey Abrams, who saw the opportunity of using direct voter engagement to change the pool of people exercising power in the state, or of Ensay Nafat Ufat of the New Georgia Project, who carried out the curing of provisional ballots, the registration of voters who didn't vote in the presidential election, and the mobilization of voter turnout, all in the space of 2 months. Or of Latasha Brown of Black Votes Matter, who connected this electoral voice to the impetus of Black Lives Matter and used this connection to mobilize the next generation of Black voters and their allies. I would add that a similar pattern worked very effectively for a completely different group of people, Latino immigrants, many undocumented, who were striving for belonging and empowerment in Arizona. This seems like an unexpected but valuable updating of Jeffersonian republicanism. But maybe it's not only Jeffersonian. Madison had a whiff of this too when he wrote, I think in Federalist 45, that people will not stop feeling connected to their states in a large republic because state institutions touch in so many ways on the activities of people's day-to-day lives. What about the second piece of language we've heard so much in the recent days since the election and the insurrection, about the need to defend the Constitution? On Tuesday, in an editorial I found somewhat surprising, Thomas Friedman in the New York Times suggested that all citizens should take the oath of office along with President Biden and Vice President Harris and swear that we will preserve, protect, and defend the Constitution. How should we feel about this kind of imperative at this particular moment? At one level, absolutely. It's an ingenious structure that's lasted more than 200 years. We see in it many of the things we value most: democratic institutions, protection of dissent, due process. It's important to affirm these things when they've been under violent attack by white supremacists and tyrants. But in other ways, the Constitution isn't simply beset. It's also implicated, not only by the failure of the checks it provided to stop an utterly corrosive presidency before the last possible minute, but in the radical racial inequality we've seen magnified by the pandemic, and in the differential law enforcement reception for the violent assailants who attacked the Capitol on the one hand, and the peaceful protesters who mobilized against police violence and structural racism this summer on the other. To me, it's hard to blink the fact that the Constitution and its interpretation by the court have helped to condition and to make plausible that differential reception. The deep implication of the original Constitution in the institution of slavery is, of course, the starting point, but not the end. The post-Civil War Constitution became implicated in racial inequality through almost a century of interpretation that supported Jim Crow and enabled violence against Black political participation. The Constitution, even after the Civil Rights era, continues to be implicated in racial inequality. Think about Washington versus Davis, which held that racially disparate effects cannot be viewed as the touchstone of discrimination. Or Shelby County versus Holder, that found unconstitutional a provision of the Voting Rights Act that provided procedural protections for racial and language minorities, rendering these groups vulnerable to new forms of voter suppression. These decisions constitutionally normalize unequal life chances and confer a sense of illegitimacy or otherness on African American, Latino, and Indigenous claims for justice. How should we respond then when on the one hand we're being asked to rally around the Constitution, to re-up and giving it our support, and on the other, the nation is hearing renewed calls for accountability on racism and racial injustice? Is it possible for us to hold both these imperatives in our minds and in our actions at once? I don't have an easy answer to this question, but I want to close by sharing an answer offered by Dorothy Roberts, a legal scholar of race, gender, and poverty that I find thought-provoking and valuable. In an essay called The Meaning of Blacks' Fidelity to the Constitution, Roberts makes the point that African Americans have not only demonstrated a fidelity to the very document that is implicated in their enslavement and subordination, they've worked assiduously over several centuries to build and improve American democracy and political institutions. Roberts argues that African Americans have defended the Constitution because they have a vision of equal citizenship toward which they strive. And the Constitution has potent instrumental value in that effort. But she's clear that it's not just any vision of the Constitution. Black leaders have been committed to an aspirational Constitution that holds the Constitution to its most capacious vision rather than its current interpretations. Frederick Douglass read this Constitution to prohibit slavery before the 13th Amendment. Thurgood Marshall read it to prohibit educational segregation before Brown, because it served the purpose, as Roberts says, of their liberation movement. African Americans, as Loretta Ross recently put it, know that they're citizens of a country that has not yet come to be. Maybe holding the Constitution to its aspirations in our own role as citizens, while vehemently arguing about its current interpretation, for those of us who are also lawyers, is one way that we can all move closer to that country. Thank you.
Thanks so much, Kathy, and thank you, Erwin, for the opportunity. I'll confess that when you gave the prompt for today as lessons learned, I had the feeling of a student facing an open-ended exam prompt, that there's just so much to say about how the Constitution both empowers and constrains policymaking in both the now departed Trump administration and in the new Biden administration. But rather than focus on those things, I want to focus on this period from Election Day to Inauguration Day around voting and the counting of votes and the certifying of votes, and of course, the violent insurrection a couple of weeks ago up until inauguration yesterday, and ask what lessons can we learn about our constitutional system and how it's performing from those recent events. And I want to posit that there are 5 lessons here that we can take away. One, around the biases toward the contemporary Republican Party created by our constitutional institutions. Second, some more kind of technocratic, nonpartisan problems with the Electoral College that I would hope Democrats and Republicans would be able to agree on, so issues other than rural bias. Third, weaknesses in election law in spite of record turnout and in spite of the success of a free and fair election. Fourth, the importance of constitutional norms. And finally, what we can learn about impeachment in these highly partisan times. So I'll march through each of those in turn. First, constitutional institutions. When we talk about constitutional law, we so often think about constitutional issues that are litigated before the Supreme Court and other courts. But there's a structural constitution that's so often taken for granted and that I think we can and should spotlight. And the structural constitution advantages the Republican Party. There's no other way of saying it. Democrats have won more votes than Republicans nationwide in 7 of the last 8 presidential elections. Each of the last 2 Republicans took office without a popular vote majority, but the Electoral College is a thumb on the scale. Another thumb on the scale is the Senate. Adam Gentleson has a new book out on the Senate as a kill switch in American democracy. And he writes that Senate Democrats have represented a majority of Americans at every moment of the 21st century. Yet, as we know, Democrats have only held the Senate for roughly half of that time. And the bias in the House is more subtle. It arises out of single-member districts, which aren't constitutionally required. They're required by statute. But the intersection of single-member districts and the distribution of population means even without gerrymandering, there's a Republican bias in the House as well. It's important to note that none of this is intrinsic. In the broad sweep of American politics, this particular partisan urban-rural divide is relatively new, and one could imagine different political coalitions that undid or even reversed the bias. But the truth of the matter is now our constitutional system puts a significant thumb on the scale. So that's the first point. It is admittedly a somewhat partisan one. The second point is, I would hope, a nonpartisan one, which is the Electoral College has problems other than the partisan biases. And there are 3 more kind of technocratic features of the institution that I want to highlight here that I would hope both Democrats and Republicans can agree aren't quite working. The first of those is the possibility of state legislatures overturning the results of state democratic processes. So as we all know, in November, Donald Trump called on Republican-led legislatures to overturn election results in states that President Biden won, including summoning, kind of in a dramatic gesture, summoning Michigan legislative leaders to the White House to try to twist their arms into doing just that. This didn't work. I have my reasons for why it didn't work. Kathy, I think, aptly provided some. But it easily could have. And I think that's the real point here, that Trump's behavior exposed a weakness in the system. And the fact that, but for a few things falling differently, the strategy could have worked demands that so long as the Electoral College remains in place, we have federal and or state legislative fixes to ensure that the winner of a state indeed receives that state's electoral votes. A second is around objections to Electoral College certification, which we of course saw on January 6th. These are objections that everyone knew would fail, but they nonetheless allowed elected officials to signal their fidelity to then President Trump. And there was a significant erosion of faith in the democratic process, the integrity of the election, I would argue, that was encouraged by those who contested the election results. Not just the violent folks outside, who we can all easily condemn, but also those lodging points of order inside the building. This wasn't constitutionally required. 3 U.S.C. 15 provides the procedures for counting electoral votes and allows only 1 House member joined by only 1 senator to force the chambers to consider an objection. And I would suggest it's a modest, but I think important reform, that this threshold is far too low, that the statute should be amended to create a much higher threshold to make it harder to lodge frivolous objections of the sort that we saw earlier this month. A final point that I think is a downstream problem from the Electoral College is the period from Election Day to Inauguration Day. So the Constitution provides for the timing of both Election Day and Inauguration Day with roughly an 11-week lag between the two. It used to be even longer. Prior to the 1930s, Inauguration Day was in March, but it's now, of course, on January 20. And this is especially a problem, this long lag, when a president loses re-election. In Sandy Levinson's words, a repudiated president has little or no political authority to make necessary decisions, while the incoming president with tons of political authority has not an ounce of legal authority. And this, he wrote it well before this year, but seems to be especially prescient given that President Trump spent his last few months in office contesting the election and continuing to ignore the need for federal action to respond to both the public health and economic crises created by COVID-19. Now, what does this have to do with the Electoral College? In short, part of the reason it takes so long to get to Inauguration Day is all the mechanics of Electoral College, of counting and certification and congressional consideration. So it would be much easier to move Inauguration Day up without the Electoral College. But even if the Electoral College remains, I think it's worth trying to expedite the transition to the greatest extent practicable. So that's the second point. The third point is around the brokenness of our election law. I don't want to understate the good news here. We pulled off a free and fair election during a pandemic. We stood up vote by mail at a massive scale. There was not evidence of fraud or foreign interference. And we had record high turnout, which is certainly something to be proud of. Though I would note parenthetically, just in comparative perspective, still much lower percentage turnout than most other OECD countries. So that's the good news. The bad news is election law remains fundamental. There remain fundamental challenges associated with voting in this country. The lack of preclearance after the Supreme Court Shelby County decision allows state level restrictions on voting. The Supreme Court has found partisan gerrymandering non-justiciable. And there are a lot of ways outside of Supreme Court decisions to make it easier to vote, from automatic voter registration to expanded early voting to making Election Day a holiday. And some states have done some of these things, but there is much, much more to do. I think it is unlikely but possible that we'll get a federal democracy reform bill that would address voting among many other issues. It depends how the new administration chooses to prioritize its legislative agenda, and most importantly, turns on what will happen with the Senate filibuster, which I think might be cut back on, but will not be eliminated entirely. And that's a conversation for another time. So that's the third point on kind of voting issues. The fourth point, and this is less of a legal one, is that the last few months, and indeed the whole Trump presidency, have shown how dependent our constitutional system is on norms. Now, I'm certainly not the first to observe the pervasive norm violations of the Trump administration, but one thing that struck me watching the period from Election Day to Inauguration Day is how law simply can't address most of the norm violations that took place in that period. Even a perfectly benevolent Congress, unencumbered by politics or any other restraints, couldn't force a president to concede an election that he lost, couldn't force a president to denounce violence, couldn't force a president to kind of enthusiastically cooperate with his successor's transition, and so on and so forth. All of this is in the domain of norms. And it's frustrating for those of us like me and most others here who are lawyers. We tend to look for legal solutions, whether legislative or regulatory or judicial. And I think on a lot of these, norms operate relatively autonomously from law. If they are to be enforced, they have to be enforced politically. They have to be enforced through voters and elected officials, making known that there will be political penalties for norm violations. But the record on that has at best been mixed. And that brings me to my fifth and final point, which is impeachment, as a kind of test of a constitutional system in an age of extreme polarization. So if anything should be grounds for bipartisan impeachment, I would argue unanimous impeachment, it should be a president encouraging a violent mob to storm the Capitol to undo the effects of a free and fair election. If anything is impeachable, that is. So I see impeachment as a sort of hard test as to whether our constitutional system still allows for accountability in an age of extreme polarization. And I think the verdict isn't great. A first point is that if Dems didn't control the House, there categorically would have been no impeachment. So right off the bat, we have reason to think that roughly 50% of the time, that is when the president's party controls the House, impeachment will be off the table. A second point is that in the vote last week, only 5% of House Republicans voted to impeach. So that's a serious strike against the idea of bipartisan accountability. There's somewhat more reason for optimism in the Senate, where there's a chance that a larger number of Republicans will vote to convict, and I'm hopeful on that score, but it's far from guaranteed. And in short, we see that by requiring a 2/3 vote in the Senate to convict, the constitutional design de facto requires a bipartisan vote, because in our age of rough parity between the parties, we'll almost never have one party with 67 seats. And polarization makes getting to 2/3 very difficult for even the most egregious conduct, like the conduct we saw earlier this month. So summing up, there are kind of 5 lessons I want to highlight here. First, the institutional biases toward the contemporary Republican Party. Second, some, I would hope, nonpartisan fixes that can be made to the Electoral College. Third, the persistent weaknesses of election law, in spite of there being much to celebrate about how November's elections went off. Fourth, the importance of norms. And fifth, and finally, kind of these lessons of impeachment as a hard test of whether we can have accountability in these really partisan times.
Thank you, John, and thank you, Dean Chemerinsky, for inviting me here today to say a few words. I'm going to be honest. I'm not yet sure what lessons I think it's fair to say I've learned in the last few terrible weeks. I'm grateful that despite the best violent attempts of a white supremacist mob, we saw a successful transfer of power yesterday. But we have so many more steps ahead of us before we know where this ends, until we know whether we're speaking the truth when we say our institutions held, our laws protected us. I also know that that reality makes this a particularly destabilizing time for law students, and maybe especially for those of you who are studying constitutional law for the first time, as you're trying to decide what to make of this document that so many Americans revere. So I'm going to use my chunk of time today to talk to you. I may not know what lessons we have learned, should have learned from the last few weeks, but we can start here. The Constitution alone will not save us. It matters who is empowered to understand it, to interpret it, to enforce it, and it matters how those people prepare for those positions of trust. I read a column this week by Nico Bowie, a constitutional law professor at Harvard. He described a letter that he wrote to his con law students, and he said, "The past few years have shaken my faith in the Constitution. Like many law professors, I once confidently predicted that the Constitution would never permit a president to ban Muslim travelers or put toddlers in cages. I also thought that the document prohibited police officers from inflicting excessive force on Black bodies, despite everything I witnessed to the contrary. Still, as recently as 2 months ago, I thought there was consensus around some interpretations. For instance, that nothing in the Constitution permitted anyone to single-handedly overturn the results of a presidential election. The white nationalists who stormed the Capitol to reject that interpretation left me questioning how long the document will survive." I found myself nodding in agreement as Bowie described a faith shattered. When I was in your shoes, I think I thought of the Constitution as almost magical. It was not only a well-designed document that would set up our federal government, dictated the relationship between the federal government and the states, and limited government's power over us, but I also believed in its power to make things so. That because it promised us equality, we would achieve it. That because it promised us liberty, we would find it. And yes, there were times where, when asked to decide whether equality could countenance the internment of Japanese Americans, or whether liberty permitted the state to sterilize a woman against her will, that the court got it wrong. But I didn't see that as the Constitution failing us. Someone just screwed up. They misunderstood the Constitution's aspirations. So I'll say again, the lesson I've learned over the past 4 years, and yes, I know that I have been slow to come to it, the evidence was there all along, is that the Constitution will not save us. Its provisions are not self-executing. They alone will not make our nation just or equitable or free. In fact, when I look at the words equal protection of the laws and see a demand to dismantle systemic racism, and an administration official looks at those very same words and sees a prohibition on teaching critical race theory, well, it's probably not the constitutional language doing the work. So what do we do with this? It is true that the text of the Constitution isn't enough, has never been enough, to ensure that those empowered to interpret it do so in ways to promote justice. If it's true that there is almost always a logically sound argument for interpreting the text in a way that shrinks rather than expands our experience of equality, then what? It matters who is empowered to interpret and enforce a Constitution, and it matters how they prepared for that position. It's not enough to know how to read the text, how to interpret it, how to make arguments about what it means. We need our leaders, which more often than not means we need our lawyers to do more than know the available range of arguments. We need them to have the ethical foundation, the moral compass, the context, history, empathy, the knowledge to get it right, which I think means we need to train lawyers differently, or maybe not differently, just more expansively. Our required courses do a really great job of teaching us to make legal arguments based on text and precedent. And we learn, as we must, to make arguments from both sides. For example, equal protection means that no one can be denied a quality education because of their race, and that we must uproot the vestiges of segregation, no matter what it takes, to ensure that Black and brown children have the same quality of education as white children. Or, equal protection means that the government must be colorblind, that the government must never take into account the race of a child when deciding where she will go to school. That, to quote Chief Justice Roberts, the way to stop discriminating is to stop discriminating. If you resent learning how to do that, how to make arguments from both sides, even arguments you don't believe, well, come talk to me. I think I can persuade you that it's an invaluable skill. To make good decisions, though, to interpret the Constitution in ways that promote justice, lawyers need more. Several years ago, Mari Matsuda, a law professor at the University of Hawaii, gave a great talk that turned into a great article about legal education. She argued that in order to be the kinds of problem solvers we need lawyers to be, to address the complexity of the crises we currently face, lawyers need a broad humanist education, exposure to history, literature, psychology, and science. She acknowledged that there's plenty of room for disagreement about which skills exactly lawyers must cultivate. But she offered a pretty good list. That's a pretty good starting place. She said, every lawyer should know how to read a financial statement, how to converse in at least one language other than English, how to respond to the basics of anti-subordination theory, including the all-important epistemological incursions into the fact-value distinction made by feminist theory and critical race theory. Every lawyer should understand what the Federal Reserve Board does, should take a course in negotiations, and should memorize at least one poem by heart. Every lawyer should do work, whether pro bono, straight up charity, religious proselytizing in the prisons, community organizing, or structural class action litigation, that gives them a direct view into the lives of our neighbors who are underhoused, underemployed, and underlawyered. Whether this is the right list or not, whether, regardless of the list, we should make more courses and more experiences mandatory to graduate is probably a conversation for another forum and another day. But we should certainly be thinking about it. And I appreciate the students past and present who have implored us to do just that. But in the meantime, you have a say in what your legal education looks like, what classes you take, what texts you read, what experiences you have. Think big. Stretch out of your comfort zone. Find ever more ways to learn what the law has to do with people's lives anyway. Turns out the Constitution needs you. Thank you.
Hi, everyone. I'm Asad Rahim. I'm very happy to be here. Thank you to the panelists. I've learned a lot from your comments, and I'm really glad. I'm new to the faculty here, so I'm very glad that I'm in this community, especially in the last few months. Okay, so I just want to start off with 3 points that I've learned. And these are not things that I think that we have learned, but they're points that I hope that we can learn. And the first is that this is lesson number 1. The lesson of permissiveness around the abuse and disenfranchisement of racial minorities will eventually threaten democracy for everyone. And in expounding on that point, I want to share my screen so I can share a quote with you. This was MLK Day on Monday, and I'm sure that you all have seen that MLK has become almost like a Disney character in our remembrance of him, such that everybody, Ivanka Trump and Ted Cruz and ICE agents are citing MLK as a personal hero. But I want to think about this quote that we have from him. And this is from 1965. He says, "The price that America must pay for the continued oppression of the Negro and other minority groups is a price of its own destruction." And so, let me stop share. And thinking about this quote, I think about Lani Guinier and Gerald Torres. They made a similar argument when they compare racial minorities in America to canaries in a coal mine. And as the analogy goes, back in the day when coal miners went underground, they would bring canaries with them. And the thinking behind that is that canaries are more affected by toxic fumes. They're affected, they can sense them before the miners do. And so when the canaries began to show agitation, the miners knew that if they stayed in the mine, they would soon perish. And I thought about that analogy a lot recently. If you look in the media and public opinion, there's a sense that the last 4 years have been unprecedented. But what I would like to say is that in the last 4 years, the America that Black and Brown people have always lived in has been experienced by a larger segment of the population. So if you take, for instance, the recent effort to overturn the election results, to functionally not count the votes of those who threatened to unseat Donald Trump, while that may seem to be new territory, there have been efforts to not count the Black vote since 1865. We know that every election cycle, there are going to be new efforts to try to disenfranchise Black and Brown voters, from purging voter rolls to shutting down polling sites in Black neighborhoods to creating voter ID laws. So there's been a routine effort to steal elections. And because we have not responded aggressively enough recently, gutting Section 5 of the Voting Rights Act, it has emboldened political leaders so that this time, they did not only try to disenfranchise Black voters, they tried to overturn the results from entire states, from Michigan and Arizona and Nevada and Pennsylvania and Georgia and Florida. And if you leave aside voting, we can think of corruption within law enforcement. This has been a complaint of Black and Brown communities for well over a century. Every week, you can scroll on social media and watch a new video of a police officer harassing or beating or killing Black women, men, and children. And yet there's almost never any consequence for those police officers, in part because we have a Fourth Amendment jurisprudence that makes police officers largely immune from legal consequence. In 2006, the FBI warned that white supremacists had infiltrated local and state police forces, and there was little done about that. It got little attention in the media or in academic circles. And the tendency to look away when police are brutalizing Black and Brown communities has emboldened a lot of police officers. It makes them feel unaccountable. And eventually, as we've seen with the protests, the BLM protests, that they began to brutalize white protesters. Or as we saw last week, some officers let insurrectionists inside the Capitol and they took selfies with them. And so protecting democracy, I believe, begins with protecting the most vulnerable within the polity. And as we've seen, the failure to adequately protect the marginalized leads to corrosion of the entire system. Number two, this is the second lesson, is that we need to begin to use race as the primary lens of analysis. I believe that part of the reason why things have gotten so out of control over the last 4 years stems from our collective refusal to discuss race until our backs are up against a wall. When Trump won the election in 2016, political pundits attributed his win to economic anxiety. They were unwilling to attribute it to race or racism. It was the economic anxiety of the working class. But that didn't really make sense, because if that were the true motivator. Why didn't Trump win the Black working class or the Latinx working class or the Asian working class? Or to take a different angle, why did he win upper income whites or college educated whites and every other segment of the white population? So I think there's often a kind of gaslighting that happens to people who think about race and talk about race. There's a sense that political issues discussed through a racial lens is too simplistic. It lacks nuance, it misses a big picture. And it's often because people of color are the ones bringing up race that there's a sense that their insistence to point out race is clouded by self-interest rather than a sober analysis of the facts. And so race ends up being marginalized as a tool of analysis. And we, as a result, are unable to recognize clear dangers ahead of us. So when Trump got into office and began eroding the rule of law, installing white nationalists in his cabinet, implementing a Muslim ban, and telling the Proud Boys to stand back and stand by, many of the same pundits who assured us that the Trump victory had little to do with racism began to cry, "This is not who we are." And the uncomfortable truth is that even if it's not who we want to be, it is who we are. And it is a refusal to look at who we are that prevents us from becoming who we can be. So we need to regularly talk about race, not just to be sensitive, not just to promote diversity, but because racism and white supremacy is a mortal threat to the American democracy. My third and final lesson is that this is not the time to relax. So I think for many of us, the last 4 years have felt overwhelming. And yesterday, hopefully, marked a transition. Like many of you, though, I woke up this morning and I read news about us returning to normalcy as a country. And I want to make 2 points on that. The first is that it's important to remember that for many communities, normal was oppressive. We need to not go back to what we knew, but instead begin to envision a better society and a better legal system. And number 2, while Trump is gone, his legacy lives on. And one of the places where he made his biggest imprint is in the courts. One president who never won the popular vote and was twice impeached has appointed 1/3 of the Supreme Court justices currently on the court and more than 1/4 of all federal judges. That means that for you law students who are interested in progressive legal change and social justice, you have your work cut out for you. You will be working within the most right-leaning federal court system that we've had in generations. But on the bright note, and I'm not just saying this to end on a positive note, but I do find that Berkeley students have some of the sharpest and clearest analysis matched with the courage of conviction. And so while you will inherit a lot of legal issues in your career, I can think of no better group of people situated to take it on. Thank you.
I thank each of my colleagues for their powerful and eloquent words. They're both sobering and inspirational. I want to talk about another set of constitutional issues that have been raised in the last few weeks, those dealing with the First Amendment. Now, to be clear, free speech doesn't protect those who broke the law on January 6th, doesn't protect those who breached the Capitol, who killed a police officer, who engaged in vandalism. No conception of the First Amendment would provide safeguards for such behavior. But there were other questions that arise that are worth talking about. One is whether speeches that were given on January 6th meet the constitutional test for incitement. The Supreme Court has said for over a century that speech which incites illegal activity is not protected by the First Amendment. Was the speech of Donald Trump on January 6th, especially when taken with his earlier words, enough to constitute incitement? What about the speech of Rudy Giuliani? I have to admit, I'm always concerned about prosecutions for incitement. I think the history of the United States shows that often people are prosecuted for incitement for speech that should be regarded as safeguarded by the Constitution. During World War I, Congress passed a law that made it a crime to criticize the war and the draft effort. The first major Supreme Court case to ever deal with freedom of speech, Schenck versus United States, involved a man who circulated a leaflet in which he argued that the military draft was involuntary servitude that violated the 13th Amendment. There wasn't a shred of evidence that Schenk's leaflet had the slightest adverse effect on military recruitment or the war effort. But he was convicted of incitement and sentenced to 10 years in prison. The Supreme Court, in an opinion by Justice Oliver Wendell Holmes, upheld his conviction and sentence for incitement. Where the court famously said, there's no right to falsely shout fire in a crowded theater. So the court said speech can be punished if there's a clear and present danger of harm. But Schenk's speech was the antithesis of clear and present danger. There was no likelihood of imminent harm. During the McCarthy era, people lost their jobs and even their liberty just for suspicion with regard to incitement. The leading Supreme Court case during that time, United States versus Dennis, involved individuals who got together to teach the works of Marx and Lenin and Engels. Just for doing this, they were convicted of the crime of conspiracy to advocate the overthrow of the United States government. The Supreme Court affirmed their convictions. The Supreme Court, in an opinion by then Chief Justice Fred Vinson, said, if the harm is as grave as the overthrow of the United States government, there doesn't have to be any evidence of imminence or likelihood. These and other cases caused me pause before saying that speech should be punished as incitement. The modern test for incitement comes from a decision in 1969, Brandenburg versus Ohio. There, the Supreme Court said speech can be punished if there is a likelihood of imminent illegal activity and if the speech is directed at causing imminent illegal activity. I think the Supreme Court got it right with regard to this test. It is a speech protective test, but it also safeguards the ability of society to preserve order. So the question with regard to Trump's speech or Giuliani's speech on January 6th, does it meet the Brandenburg test? I think so. Focus on what Donald Trump said on January 6th. And it has to be put in the context, the time, the context of what preceded it. Was there a likelihood of imminent illegal activity? When you look at the nature of the crowd and you look at why they were there was certainly that likelihood. The fact that imminent illegal activity then followed certainly reinforces that it was likely to happen. Was the speech directed at causing imminent legal activity? If you read Trump's speech, 20 times he used the word fight. Fight there was not metaphorical. Fight had to be taken as literally encouraging the audience to go and fight. Standing next to him was Rudy Giuliani. Rudy Giuliani said, among other things to the crowd, that there needed to be, quote, trial by combat. Trial by combat isn't how we use our words to resolve disputes. It is about fighting and violence. And so I think it was appropriate for the House of Representatives to say that Donald Trump's speech incited illegal activity. I think it would be appropriate for courts to indict Trump and Giuliani for incitement, even though I am always reluctant to see people punished for incitement, believing it should be used only in situations like this, where there really is a likelihood of imminent activity and the speech is directed at causing it. A second free speech issue that's come up concerns Twitter and Facebook. As you know, Twitter imposed a lifetime ban on Donald Trump being on that platform, and Facebook imposed a ban for a period of time. Immediately when this happened, I received a lot of calls from reporters saying, doesn't this violate the First Amendment? And the answer to that question is clear. The First Amendment doesn't apply. The First Amendment limits what government at all levels can do. But the First Amendment doesn't apply to private companies or even private universities. Twitter, Facebook are private entities. The First Amendment doesn't apply to them. Now, when I said that to one reporter from a major newspaper, his response was, Professor, are you sure about that? And the answer is, yes, I'm sure that Twitter and Facebook don't have to comply with the First Amendment. But even though the First Amendment doesn't apply, free speech principles could still apply, not as a legal matter, but as a matter of what for our society should we want with regard to freedom of speech. I have to admit here that I have mixed feelings. On the one hand, I was delighted that from January 8th until January 20th, we didn't have to have President Trump's tweets repeatedly reported in the media. I would be delighted if Donald Trump no longer could use Twitter and if we didn't have to listen to him over that medium. And yet a larger part of me is concerned by the power that Twitter or Facebook or Google, YouTube can exercise over the ability of people to speak and the ability of people to receive messages. To me, free speech is all about people being able to express their ideas and receive the ideas of others. I don't think it's different if it's Twitter or Facebook censoring speech than the government in terms of the ability of people to speak or receive ideas. If a website can't be accessed over Google, isn't it the same as the website not existing at all? If we can't see videos over YouTube, isn't it as if they're not there at all? And I'm concerned about the ability of private media companies to then exercise so much control over what speech can be heard, what can be listened to by those who want to view it, those who want to receive it. Donald Trump had 80 million Twitter followers. They're no longer able to get that message. Now, to be clear, I think that Twitter or any social media platform can take speech down if it constitutes incitement, or if it constitutes invasion of privacy as the law defines it, or if it meets the legal test for defamation. But I am troubled by the idea of a lifetime ban of anybody, including Donald Trump. Third issue that I want to talk about is, what about the First Amendment in the false speech that was uttered? Another question that I received so often in the last couple of months: why can't Donald Trump's false claims of election fraud be stopped over social media, stopped generally in society? Shouldn't we be able to stop such false statements which can cause great harm in society? And the answer to this is that generally false speech is protected by the First Amendment. There was a Supreme Court case about 8 years ago, United States versus Alvarez. It involved a federal law, the Stolen Valor Act. They made it a federal crime for somebody to falsely claim to have received a military honor. And a man in Riverside, California, falsely claimed to have received the United States Medal of Honor. And it was quickly pointed out that he hadn't. The federal government prosecuted him under the Stolen Valor Act. The Supreme Court 6-3 declared the Stolen Valor Act unconstitutional. Justice Kennedy, writing for the plurality, emphasized that false speech is protected by the First Amendment. In 1964, in New York Times versus Sullivan, likely the most important free speech case ever decided, the Supreme Court said there has to be protection of false speech in order for there to be the breathing room that free speech needs in order to thrive. Now, this isn't absolute. Free speech is never absolute. Lying in court under oath is speech, but it's perjury that can be punished. False advertising can be punished. But generally, false political speech, whether it's from the president or anybody else, is protected. Undoubtedly, false speech can do great harm. Donald Trump's repeated false claims of election fraud caused many in this country to believe that it occurred, even though there was not a shred of evidence to support the conclusion. I think that the internet and social media cause us to rethink basic First Amendment principles. It is so easy for anybody to put false speech on the internet and reach a mass audience. How should we think about this from the perspective of the First Amendment? On the one hand, the internet and social media have tremendous benefits with regard to free speech. They've democratized the ability to reach a mass audience. It used to be, in order to reach a large number of people, you had to be rich enough to own a newspaper or get a broadcast license. Now anybody with a smartphone or access to a media modem can reach a very large audience. Also, all of us can now have access to unlimited amounts of information in every area by going on the internet. And that's a tremendous First Amendment value. But there is also the great harms that can be done by the ability to use social media and the internet. Harms in terms of false information, harms in terms of hate speech, harms in terms of marginalizing people in our society. The First Amendment is based on a faith that ultimately we are better off allowing everyone to speak and express their ideas than we are to allow anybody to control what can be said and what can be heard. I share that faith, but I think we need to rethink how to apply it in the context of the internet and social media. In the last couple of months, definitely raised concerns about the problems that cheap speech over the internet and social media can cause for all of us. So with that, we've left time for questions, and let me read the questions as they come in. The first question, Josh Hawley is a Yale Law School graduate and Ted Cruz a Harvard Law School graduate. Both have been active in the Federalist Society throughout their careers. To what extent are elite law schools and judicial organizations like the Federalist Society complicit in creating, sustaining, and perpetuating the white supremacism that led to the attempted coup on January 6th? I don't know if anyone in particular wants to take it, if I should direct it to a particular person. Kristen, since you spoke most about legal education, do you want to talk about that? And then anybody else?
I'll try. So my personal belief is we're complicit. That legal education and the legal profession values, I don't know, eliteness, hierarchy, power in ways that gives people passes even when they are doing objectively terrible things like enforcing white supremacy. And that the way I believe that we need to vocally reject it, but I also believe we need to collectively work on elevating other values within our institutions, right? Besides power, elevating values of justice and collectiveness and empathy. So that's my position.
Do others want to speak to that?
Yeah, can I just add a little
Please.
bit? So I think that to the extent that elite universities are complicit, it's that you can get, as an individual, as a student who has graduated from these universities, you can go very far, graduate with honors, and not have any understanding of race or white supremacy. I'm always shocked by that. Like, meeting people who are super well educated, but don't have a sort of fundamental understanding of racial issues. And so when I was at Harvard, I went there for law school, they implemented an international law requirement that everyone had to take international law. And that's the institution indicating to students that this is vital that you know this. The truth is, most of us are probably not going to work in international law, but most of us will have to navigate our racial society. And so the fact that you can have, I don't think it's the job of elite universities to force people to think a certain way, but you should be exposed to certain viewpoints such that it helps to mitigate your views and helps you challenge yourself. And you should leave and be and question yourself and question your views and not be so steadfast. And I think the lack of exposure to curriculum around race ends up producing certain leaders who don't have basic understanding.
I'll go to the next question if that's okay. Could you discuss what the Protecting Our Democracy Act would mean in terms of electoral reform? John, I don't know if you wanted to discuss that because you were discussing this.
Yeah, sure. So we've seen several iterations of proposed legislation to protect democracy. When Democrats first took the House two years ago, they opened the session by passing H.R. 1, which was a kind of comprehensive democracy reform bill that implicated issues around voting and campaign finance and foreign interference and many, many other things. It didn't become law, of course. The Protecting Our Democracy Act, I believe, there've been a number of bills with similar names, so my apologies if I'm off here, but my understanding is that the Protecting Our Democracy Act is a bill that would look to prevent foreign interference in US elections, and in particular, kind of with both a retrospective element of investigation and kind of prospectively seeking to prevent that interference. And I think obviously foreign interference is a scourge, and I've not studied the legislation closely, but any measures to prevent it are ones we should take seriously and think seriously about. I don't know if there are more details, Erwin, or more that I can say.
Sure. Does anyone else want to speak to that question? Kathy? Kathy, are you?
Yeah. I certainly, and I am not familiar with all the content in this bill either. So speaking more generally, I think I salute the prevention of foreign interference, but I also would say that I think one of the most imperative things right now is to restore the provisions of Section 5, if we possibly can, of the Voting Rights Act. And I assume that that is included in the piece of legislation that's called the John Lewis Voting Rights Act. Is that correct? And there have been so many ingenious, renewed efforts at forms of voter suppression that particularly target communities of color, people with low incomes, and sort of ancillarily get other populations like the elderly, that it seems like at least we should address those that clearly have the intent and the effect of making it harder for people of color to vote. And the fact that, I think that everybody remembers what Justice Ginsburg said about the voting rights case, when she said that it's like saying getting rid of Section 5 is like saying that you're going to throw away the umbrella because it's protected you from the rain. You should not be able to use evidence of the success of these provisions in preventing voter suppression and voter dilution as a vehicle for getting rid of them.
Thank you. Go to the next question.
Can I jump back in briefly, Erwin? Sorry about that. I just peeked. There was an older version of Protecting Our Democracy Act that was restricted to foreign interference, and I just saw the newer version of the bill under the same name is a much broader suite of reforms involving transparency, addressing the pardon process and presidential financial conflicts of interest. And kind of a whole suite of reforms. It doesn't include the voting rights issues that Kathy was just talking about, though other legislation does. And I think it's very clear that democracy reform is on the agenda. I guess I would say one thing that strikes me about both the Protecting Our Democracy Act and some of the kind of executive power related provisions in there, as well as the voting rights related legislation, is that all of it has been written very, very carefully to kind of circumvent both the existing and anticipated future constraints put on by a conservative judiciary. So I think the task in writing any democracy promotion legislation is twofold. Part one, which is difficult, is how do we do this in a way that complies with existing precedent? And part two, which is far more difficult, is how do we do this in a way that complies with anticipated precedent by a court whose composition has moved considerably to the right. So for example, in the Protecting Our Democracy Act, there aren't direct restraints on presidential pardon power. because those would almost certainly be struck down. There are kind of disclosure related requirements and kind of adjacent reforms. And I think we're going to be seeing a lot of this in democracy reform, I fear to say, over the next couple of decades, that if the court remains conservative, many of the more kind of direct, intuitive fixes to these problems are going to be off the table. And it's going to be a matter of very creative lawyering, mostly in the legislative branch, of how do you craft laws that will plausibly be upheld. And then, of course, by litigants to defend those laws if and when they're challenged.
Thank you. The next question. I'm quoting, in my view, we need some constitutional amendments. One, amend the First Amendment to A, remove hate speech from its protection, and B, prevent blatant lies by the media, perhaps by imposing substantiation rules on news outlets, similar to those the FTC imposed on advertisers, and two, prevent the recurrence of much of the corruption of the Trump administration, perhaps by expanding Emoluments Clause. Thoughts? If it's okay, let me try to take that first crack at that. And I'll go backwards to the question. In terms of the Emoluments Clause, these are two provisions that limit the president or any executive official from receiving benefits from foreign governments, or one says the president can't receive any benefit other than the salary paid for the office. On January 23rd, 2017, I was co-counsel in a lawsuit filed in the Southern District of New York challenging President Trump for violating the Emoluments Clause. Two other lawsuits were filed, one in DC by members of Congress, one in Maryland by two attorney generals. We are now at January 21st, 2021, and none of those lawsuits have gotten past litigation over the question of standing. The Second Circuit ultimately found in our suit there was standing, and there's now a cert petition in the Supreme Court. Other courts came to other conclusions with regard to standing. It is just outrageous to me that we take 4 years to litigate the jurisdictional question when every day the president was violating the Emoluments Clause. I don't think we need to strengthen the Constitution. I think we need to create a procedure whereby the courts would take claims like this much more seriously and expeditiously. In terms of amending the First Amendment, I'd be very concerned about that. In terms of amending it to say that false speech isn't protected, I worry about who's going to decide what's true and what's false. Do we really want the president or a federal agency to be making that determination? As I said earlier, the idea of the First Amendment is we're better off having everything expressed than having somebody decide for us what's true and what's false. We could do a whole program on hate speech, and there may be disagreement among us, but I've written extensively about this, been concerned that there's no way to define what's hate speech that's not vague or overbroad. Over 350 college universities adopted hate speech codes in the early 1990s, and everyone to be considered by a court was struck down on vagueness and overbreadth grounds. Also, if you look at how hate speech laws have been used in Europe when they exist in the United States, so often they're used against the people they're meant to protect. When the University of Michigan adopted a hate speech code, every attempt at discipline under it was brought against a Black person or individual of Latinx descent. Ultimately, I wish there wasn't hate speech. I know it causes real harms, but I think the effort to try to ban it would do much more harm than good. Other panelists who want to speak to that question?
I'm wondering about, I was really cheered and struck by your defense of the notion of incitement according to First Amendment law in the Trump case. And I'm wondering if there are cases involving hate speech or pornographic speech, or where you can see that kind of a direct incitement effect.
I think with regard to hate speech, there are instances where you could say it causes a likelihood of imminent harm, and there's speech directed at causing imminent harm. I think that if you look at what went on in Charlottesville at the time, I think there the hate speech could be seen as, in that context, incitement. I find it much harder with regard to pornography. I know there was an effort to try to ban pornography for sex discrimination. The Seventh Circuit in the Hudnut case declared it unconstitutional. And I think that's right, because I think it's very hard to link it to imminence when it's people watching pornography. And I think that the McKinnon-Dworkin ordinance that were challenged there We're much more about trying to stop an idea or enforce a moral judgment than what we could really think of as incitement. And I realize we've just covered a huge amount of First Amendment law in about 2 minutes.
Yeah.
We're also at 2 o'clock. Before we adjourn, do any other panelists want a last word? Anything else? Asad,
I was going to say thank you. That's it.
oh,
Really.
it's my thanks to you, Asad, and to Kathy and Kristen and John for your just wonderful presentation. Next week, at this time, Thursday, January 28th, from 12:50 to 2, we're going to do a program on the initial efforts of the Biden administration. And we're going to focus on the environment, in immigration, in labor, in education. And I hope so much you'll join us for that program. Thanks to all of you who are watching. And once more, thanks to the speakers for the terrific presentations.